Hello, and welcome to today's podcast, Record Retention for Nonprofits, Keeping Track and Keeping Up. My name is Jason Q. I'm a staff attorney at the DC Bar Pro Bono Center. Our mission is to provide pro bono legal assistance to nonprofit organizations in Washington, D.C. Today's podcast is part of a series organized by the Pro Bono Center, focusing on practical challenges that nonprofits face on a regular basis. On our website, you can also find webinars, newsletters, legal alerts, and other resources covering a wide range of nonprofit legal issues. That website is www.lawhelp.org/DC/CED. So today we'll be discussing the nuts and bolts of record retention for nonprofit organizations. Joining me is Regina Hopkins, Assistant Director of the DC Bar Pro Bono Center. Regina oversees the nonprofit and small business legal assistance programs here at the Pro Bono Center and has extensive experience in nonprofit governance and the laws relating to tax-exempt organizations. Before joining the Pro Bono Center, Regina worked as a tax attorney for almost 10 years before heading to Habitat for Humanity, where she served as Vice President and General Counsel. Hi, Regina.
Hi.
Hi. So our topic today, record retention, can certainly be an important practical consideration for nonprofits, but we should talk about the legal ramifications as well.
Okay, yeah. That sounds great. Well, first off, there are certain requirements that both the IRS and the DC Nonprofit Code impose on nonprofit organizations with respect to their records. And the first one we'll talk about is the IRS. The IRS requires that nonprofits retain permanently a copy of their Form 1023. That's the application they filed with the IRS to obtain tax-exempt status. The IRS wants you to keep a copy of that record and make it available for public inspection for anybody who asks to see a copy of it. So if you're a member of the public and you're interested in the tax-exempt status of, say, Habitat for Humanity, and you want to see their application for exemption, you can write to the organization or visit them at their headquarters or some other thing, or go online and ask for and see a copy of their 1023 application. In the same vein, the IRS wants nonprofits to keep available for public inspection for 3 years copies of the organization's Form 990. That's the annual information return every tax-exempt organization files with the IRS. Now, based on your size, you may file different forms. Organizations with income of $200,000 or more generally file a full 990. If your income is between $50,000 and $100,000, you'll file a 990 EZ, which is similar to a 990, but just it's got fewer questions and details. And then organizations whose income is $50,000 or below file an e-postcard. They go online to the IRS website and they file an electronic form. They don't have to provide a copy of their form for public inspection because the IRS just does it themselves. Anybody can go on and see, just go on to the IRS website and you get a copy of the 990s filed by those entities. But otherwise, you have to have a copy of your 990s available for 3 years following filing so they can be inspected by the public. And basically the reason why the IRS wants both the application and the 990 available for public inspection is that it's the idea is that these are, as a tax-exempt charitable organization, you get certain subsidies from the government through the tax code. You don't have to pay income on your taxes on your income, and deductions to your organization are tax deductible. And to justify that, the IRS, with the Internal Revenue Code, Congress, when they enacted the Internal Revenue Code, said that there should be a level of transparency about your activities so that the public can see that their subsidy of your activities is justified. And so they want it available for public inspection. So that's on the IRS side.
And Regina, on the IRS side, are there penalties for not maintaining the 1023 and the 990?
Yes, you can be fined by the IRS if someone comes and asks for a copy of your 1023 or your 990. You can be fined if you cannot produce it within the time frames. If they come to your office, you're supposed to immediately give them access to a copy. And if they write in or email you and ask for a copy, you have a certain number of days that you are allowed to respond to that. So if you don't satisfy the timelines, you can be subject to penalties.
So there are some teeth here with the IRS.
There are some teeth here with the IRS, yes. And then the DC Code itself, they want you to maintain certain records. They want you to maintain your articles of incorporation and bylaws. They want you to maintain minutes of your meetings and your accounting records for the past 3 years. Your periodic filings, like your basic business license filing and your biennial report to the DC government, they want you to maintain copies of those. There's no penalty if you fail to do that, but say a director or somebody, the Attorney General, could sue for a copy of those records, and if you couldn't produce them, then there might be some sanctions or fines there. So you know, it's not quite it doesn't have as much teeth as the IRS requirements, but it nonetheless could be come back to haunt you if you could not produce those records, say, on audit by the Attorney General. So that's why those records also have to be kept.
Another important area of records that we should talk about are employment records, and I understand that there are some affirmative requirements here as well.
Yes, there are. Both state governments, and in our case, the DC government, and the U.S. Department of Labor want employers to maintain payroll records. Particularly, this is to ensure that you're satisfying the wage and hour laws. Generally, 3 years is the appropriate length, but in some states, they can be as much as 6 years. So if you have employees, for example, in California and New York, you may have a longer period of compliance or record retention compliance that you have to deal with. But basically, they want you to go back at least 3 years to keep those records. And also, the IRS expects you to transmit payroll taxes. And like any tax return, you want the records to justify or back up those records while the return is open to audit. But the idea is that you can be audited by the government to ensure compliance with wage and hour laws. And so they want the records available so that they can inspect it. So that's another area that's pretty important. There are a few others, like OSHA may require certain records be kept of employee accidents, and depending on whether you're a federal contractor or grant recipient, you may have to keep your employment, your equal opportunity records. But those are the big three, and so those you definitely have to keep track of. There may be others depending on your funding or whatever, but you can start with those three as being really important.
Great. Something I want to circle back to are meeting minutes, and we had mentioned that the DC Code requires you to keep meeting minutes for 3 years, but I think this is an area where a lot of people are thinking about, because it's a record that they deal with pretty commonly. So are there sort of best practices for keeping meeting minutes?
Yes. Well, first off, the IRS on the 990 will ask you, are you keeping contemporaneous records of your board meetings? And they define contemporaneous as basically, are you writing up the minutes within 60 days or before the next board meeting, whichever occurs later. So if you have a meeting every month, you have 60 days to write up your minutes. If you have a meeting every quarter, you can go out to the next board meeting, but you're supposed to keep it in real time, basically.
Okay.
And they say whatever satisfies state law. So it could be an email summary, or it could be a formal minutes. It depends on what your practices are, but there should be some contemporaneous summary of what you're doing. And basically, the way the best practice is to keep those records permanently, because they are sort of the historical DNA, if you will, of your organization. Mm-hmm. Someone will say, well, how do I know you were validly elected as a director 8 years ago? Well, you can go back to the minutes. And so it is a way to keep track of essentially the history of your organization in a pretty concise manner. Mm-hmm. I will say one thing: people tend to overwrite minutes. They tend to make them way too long. They tend to make them more of a transcript of a meeting, and that's not what we mean by writing minutes. Minutes are just a summary. Like, for example, the treasurer reviewed the proposed budget for the board. The board, he went through the projected income and expenses. The board asked questions. The board voted to approve the budget. Something like that. That's all you really need to keep a record. You don't need to keep a record of the back, and in fact, you shouldn't keep a record of the back and forth of the discussion. I think those income projections are too unrealistic, or things like that. Those are unhelpful if you ever get sued. So you just want to keep a record of what was proposed and what was voted on. That's basically it.
And does this also cover board committees as well?
It would cover any committee that has to make decisions on behalf of the organization. If a committee is just making recommendations and the board makes the final decision, then it's enough to keep the board minutes. But if the committee is delegated with the authority to pick an auditor or set the compensation of an officer or approve changes to the budget, then those final decisions should be put in a record as well.
And we've been talking about board meetings, but sometimes the board will take actions outside of a meeting, and there should also be records of those actions as well.
Right, but we need to be clear about that. The board can, basically, the way a board can act is it can only act at a validly called board meeting in which a quorum is present and proper notice has been given. So you have to, if your bylaws say 4 days notice, you have to give 4 days notice, and you have to have a quorum sufficient to act, and then you can vote on matters. There's one exception to that requirement, and that is what's known as unanimous written consent. And what that means is, if say you have 11 directors, you can write to them, or you can even email them and describe the action you want to take, and say, we want to approve this purchase of this equipment. And if all of the directors respond, and all of them respond in the affirmative, then you can take that action without a meeting. But if, say, you had an 11-person board and 9 people responded, and 7 voted yes and 2 voted no, that would not be sufficient. Or even if 9 people responded and they all said yes, that's not sufficient, because it has to be, you have to hear from every board member and they all have to agree. And if they respond in email, that's acceptable under the DC code, but you should keep a permanent record of those emails and keep them with your minutes, because they are the functional equivalent of a minute.
And that record, you'd better be able to identify who each of the individual board members are. Sometimes the email addresses aren't clear about the identity of the person, so you have to make sure that you have a signature or something.
Exactly. It should be like if you get an email from me, it will say Regina Hopkins, Assistant Director, DC Bar Pro Bono Center. That's clear. But if it's shopgirl at yahoo.com, fine by me, R, that's not going to be sufficient for you to rely on. There has to be some footer or some email address or something that shows that that you can, with some degree of confidence, say that I have responded.
Got it. So we talked about meeting minutes, maybe a best practice being to keep them permanently. Are there other records that should be kept permanently?
Yeah, I think although you don't have to keep your 990s, a lot of people think you should keep them permanently. Again, it's the DNA of your organization. It's the trail. It's the historical spine of your organization. So that audits are another thing that people often keep regularly. One important thing that people overlook is their insurance policies. Those definitely should be kept permanently. People don't realize this, but a lot of policies cover an occurrence even years after the policy has expired. Let's say you have a general liability policy, and and someone gets injured, and they don't sue you to 6 years later, or because of their age, the statute of their young children, they don't have to start suing you until they're 18, and then the statute of limitations runs. So you may be getting a lawsuit 20 years later. That insurance policy that you had, say, in 2007 is still in force. It will still provide you with coverage. If you know that you have the coverage and you know who to call to ask for the coverage. The problem sometimes people have is that they throw the policies away and they don't even remember who their insurance carrier was then. So even though they have insurance to cover the claim, they lost policy and they don't know who to call. And so that's a problem. So it's a good idea to keep your insurance policies forever. So that's one example. The other may be other similar, like deeds, mortgages, any property, things like that, or records that may be something that you want to go back in time. If you received a restricted donation like an endowment, that the restriction's not going to expire. So you need if there's a deed of gift or something like that, you should keep that permanently. So if years later you want to say, maybe we should spend it on X or Y, you have to go back to the original document and see whether that's permitted.
Great. I think we still only kind of scratched the surface of the kinds of records that organizations should be thinking about, and it's going to vary depending on the organization, but there could be leases, there could be contracts, there's all sorts of financial records. So something that we recommend are that people get a record retention policy in place for their organization. Can you talk a little bit more about record retention policies?
Yes, there are record, and you can get them online, and you can get them at our website as well, sample record retention policies, and they'll go through the different things. Contracts, like if I lease a copier, generally speaking, I can only be sued with respect to that for a certain limited period of time, what's known as statute of limitations. And so once that statute of limitations expires, I don't need the contract anymore. The same with personal services contracts or other things. I don't need them forever. So you may want to get rid of them at that point. And it will vary depending on the type of record. Bank records have a certain lifespan of something. Tax records, generally your donors, for example, can be audited for up to 6 years. So you want to keep your donation records for 7 years. So if they come back to you and say, can you prove to me, to the IRS, that I gave this donation back in 2010, you can say sure, and you can pull out the record. And that way, they can do that. And that's, does the organization need the record? No, but the donor may need the record, and so in order to please your donor, you want to be able to respond to those types of requests. So you do want to keep records for various lengths of time depending on the type of record, and a standard record retention policy will list the various time frames for different types of documents.
Great. It's a good way to keep things organized.
Exactly.
Keep everyone on notice. We've been focusing on record retention, but the other part of this that's really important is record destruction.
Right.
And I think that's something that people tend to overlook.
Yes. Once a record doesn't have to be kept, it's important that you get rid of it. And not only get rid of it, but get rid of all copies of it. And the reason is, let's say you're sued for sexual harassment, and there was an incident 10 years ago. That you had to deal with. If you had destroyed employment records in a timely manner or litigation records in a timely manner, those records would be gone. And when you got sued, they'd say, produce all your records. You could say, here it is, and you wouldn't have to tell them about it because the record isn't there. But if you have kept the record, if you did not destroy it in a timely fashion, you're going to have to produce that, and it's going to make your situation worse. Once old records don't help you because they're not enforceable anymore, because the time has expired, or their usefulness is not there, or the information isn't timely. They don't give you any plus. They can only come back to bite you. They also make it difficult if you get sued. You'll be asked to produce all records relating to wage and hour law. And if you have 20 years of records, someone's going to have to go through 20 years of records, and that is an enormous time-consuming request. And it's just going to eat up a lot of time for you and for your organization. So that's another reason why. And then the third reason, I think, is you can drown in a sea of records. If you keep everything, then it's hard to find the stuff you really need.
Right.
So that's why it's important to cull your records from time to time and keep what you need to keep and get rid of everything else.
That's another part of your record retention and destruction policy that you should be actively enforcing. Don't just have it on paper. Really encourage people to purge their records. Right. Or organize purge days to go through your records. Exactly,
because even if you have a central filing system, whether it's online or it's in a file cabinet somewhere, if it's in somebody's desk drawer, then the organization still has the record.
Right.
So when that request for discovery comes in, it's not just the main files that get checked, it's everybody's files. So if you have people who are hoarding records, and you know who they are, they're the record hoarders, they're the people who have like tons and tons and tons of paper in their office. If they're hoarding the records, then you have to go through every one of those to see whether they kept copies of anything. So it's important. And another one that people do, and it's sort of the electronic hoarders, is people who on their personal drives or in their computers or in their email boxes, they have emails going back 10 years.
Right.
Those are records too. They should be subject to the record retention and destruction policies. If it's about a contract, you get rid of it when you get rid of any other contract. If it's about something that's permanent, then you keep it permanently. But again, records, electronic records, you have to keep track of them as well. And it's also a good thing if you can afford it. There are software programs that you can store your records in, and they will automatically prompt you to delete them at the appropriate time.
And especially with email, the emails themselves are a record, but nowadays so many emails have attachments to them that are also records. And so if you're not going through your email and purging those, you're actually probably going to have records on your server as well. Yes,
and it's just going to, it will be something that just is, again, only can come back to bite you.
Because that reminds me of another topic, is we've talked about kind of what to store, but there's also sort of the how and the where, especially when it comes to access and security and who should be holding the records. Are there sort of general best practices there?
Yes, I mean, you do want them centrally stored somewhere where people can get access to them as appropriate. Certain records like healthcare records or HIPAA, things that are covered by HIPAA have to be specially stored. But in general, your general records should be stored someplace. If you keep physical copies of certain documents, which you will, like deeds, mortgages, things that have stamps on them and where you might want an original signature, you can store them in a fireproof filing cabinet somewhere so that if you did have a fire, the records have a chance of surviving. Otherwise, you can scan them and store them in the cloud, because under DC law and federal law, a scanned record is as good as the original paper. They don't differentiate between the scanned copy of the record and the actual original piece of paper. The scanned copy of the letter is the same as the letter. And so you should do that. And you should also make sure that the systems are backed up, that you have security protections, that you store them on a secured server or something. And then the other thing is that more than a person has access to the records. I had a nonprofit who unfortunately fired an employee who had the only password to the records. And after they fired her, they said, "Oh, can you give us the password?" And she said, "No, you fired me. No, I'm not giving you the password." So she had to actually they had to go and hire a hacker to hack their system so they could get access to their records. So you make sure that you have more than one person with access. And this is especially true of volunteer organizations. Oftentimes it may be on a volunteer's computer, and they leave the organization, sometimes under good circumstances, sometimes not. And unfortunately, the record leaves with them. Or there's a crash, the system crashes and they don't have the record anymore, or they get rid of their laptops. So you want to make sure that even if it's in a Dropbox folder or a Google Docs folder or something like that, that you have stored them someplace that is, not dependent on someone keeping a box in their basement.
Great. Oh, so after this is a lot of information, and I think people are going to wonder, like, what kind of proactive steps could I take with respect to our organization's records? And it's the summertime, people might have some time to get their record retention situation under control. So any tips for next steps?
Yeah, the next step is to look through your records. Do you have a copy of your 1023? Do you have a copy of your 990s? Do you have copies of your minutes? Now is the time to look. It's a great volunteer project. If you have a volunteer who could go through and help organize the records, that would be great. And if you don't have copies of, you're missing a copy of your insurance policy, you can write your carrier and get a copy. Better that you do that now than wait until there's a dispute with your carrier. And now you're asking, can you send me a copy of my policy? You want to do it before there's a problem.
Kind of like a record audit.
A record audit. You can also write to the IRS, and they will send you back copies of your original application or your 990s if you're missing. Your attorney that helped you, if you had an attorney help you, they may have a copy of those records. it's good to do it now while people still remember the names of people or the former board member who was a secretary. They may have a copy of missing minutes or something like that. So to get it and fill it out as much as you can. You may not be able to replicate everything, but as much as you can. This is a case where the longer you go out not supplementing or augmenting these records, the more likely it is that they will be permanently lost. So, it's, as I said, if you have a volunteer who, can dedicate 10 or 15 hours a week to this or 1 day a week to this, that would be great because it gives you a chance to have them, just do some of the due diligence of getting copies of things.
Awesome. Well, great. That was very informative. Any final thoughts with respect to record retention? Well,
just this, that it's one of those things. It doesn't seem that important until you have to get that record, and then usually it's unlikely that someone says, "I'm going to need this in 3 months."
Right.
They're going to want it tomorrow, and then you're scrambling and you're trying to figure out how to do it. So. Setting up good practices now and filling in as many gaps as you can in your records now is good. So when that "I need this in 2 days" request comes through the door, then you're able to satisfy it.
You're ready.
You're ready. Yeah.
Okay. Well, great. Thanks for joining me today, Regina.
Thank you.
Awesome.
Bye.
Bye.